Call now Advent Oil and Operating, Inc. against S&E Enterprises, LLC.
Good morning. My name is Robert Beasley, Litvak, Beasley, and Wilson. On behalf of the appellant Advent Oil, I'd like to reserve 3 minutes for a rebuttal. The complaint in this action is a breach of contract causation issue. The contract between the parties was called a joint venture ownership agreement. The complaint was filed in March 2004 and alleges that Advent failed to complete a saltwater disposal well within 120 days. It was not complete and operational according to the contract terms. At the time of filing in March of 2004, the saltwater disposal well was complete and operational and had demonstrated its ability to receive fluids from November and December of 2003. At the time of filing, the ground lease, which we call the Young lease, that's the lease to which the well was on, leased by Mr. Young, had been extended and was in force. This case jumped off tracks in January of 2007 by a motion for summary judgment when the plaintiff came to the court and said, "Judge, this contract has been breached because now the lease has been terminated." This lease, and it's a matter of record in 486 of the record, states that it's held by production, which means that the tenant pays 1 year and then it's renewable annually if they're producing oil because the landlord receives a commission off of the production. And that's a typical land lease for Oklahoma. The lease had been terminated between 2004 and 2007 because the operating well, which we call the Payne well, the oil well was no longer producing oil. S&E was an investor in the oil well. The oil well was initially successful, but it produced a lot of salt water. The investors of the oil well needed a way to dispose cheaply of the salt water. So they got with Advent, S&E, and Advent went in and formed this other venture, this joint venture, to build a saltwater disposal well. And in this joint venture agreement, you'll see the whereases which frame the situation.
All right, so S&E and Advent both had interest in the oil well as well as in the saltwater disposal well.
Yes, Your Honor. Advent was the driller and operator of the oil well in which it had an ownership interest. S&E was an investor, a passive investor, one of many in the oil well. The oil well was producing volumes of salt water that had to be disposed, and it's expensive to dispose of that salt water. So the solution for that oil well was to open an old well and call it a saltwater disposal well. S&E and Advent formed this agreement to do that, to open a saltwater disposal well. At the time, they had one well producing volumes of salt water. They anticipated or planned on drilling a second well. Well, this all collapsed when the oil well stopped producing oil. It got clogged up with a barium sulfate problem. The saltwater disposal well was constructed. The evidence is undisputed that it was completed and operated according to the terms of the agreement, operational within 120 days. It was permitted by February of 2004. So it's sitting there as a vessel to receive salt water. What the trial court did is sought equity to interpret this contract to add terms in a way that got Mr. Farrell and S&E his money back, basically. What they did was they said, this contract has performances guarantees. Well, it doesn't. In the two whereas clauses, and that's it. The two whereas clauses is what we're talking about. It says Advent plans to drill other wells in Kay County in Oklahoma. And some of these wells will require an economical way of disposing salt water. Third whereas clause. Whereas Advent plans on drilling Payne number 2. It's the other well. And if Payne number 2 proves commercially productive, that's its own term, then we might need a saltwater well. And so therefore the parties, and the other whereas that wasn't issued by the trial court, which is just as important, is whereas right now we have Payne number 1 that's producing volumes of salt water.
All right, what about this language in the contract?
Yes, sir.
Advent specifically guarantees a saltwater disposal well capable of a minimum capacity to produce revenue sufficient to recover S&E's venture capital investment of $250,000 plus 7% interest in 4 years from the date of receiving funding from S&E. Now, before the 4 years elapsed, the well was closed, right?
Before the 4 years elapsed, the lease terminated because it was not held by production, and the well had to be abandoned under the terms of the ground lease. and the saltwater well was removed. But that's not what paragraph 7
So
guarantees.
wasn't that guarantee breached at that time?
Well, the guarantee, specifically guaranteed in the first line, is a saltwater well capable of a minimum capacity to produce sufficient revenue. The only question is, was it capable of receiving sufficient capacity? Because wells could receive X or Y capacity. It is undisputed that it was capable of receiving, as of November of 2003, 3,000 barrels a day, which was more than sufficient for the return. The question is, did Advent guarantee the saltwater, or did it guarantee a vessel capable of receiving saltwater? There is no guarantee in here that Advent is going to go fetch saltwater from anywhere and put it in this vessel. The parties contemplated. Turns out they were wrong, but the parties contemplated, and you see it in the whereas clause, that they needed this vessel to receive fluids. Advent said, I'll build you this vessel, and I guarantee you it is capable of a minimum capacity to produce revenue. So then when it doesn't work out, and their joint venture plans don't work out, and the lease terminates, this other lease terminates, and he has to remove the well, the trial judge in the summary judgment, and that's where we jump off track in January of 2007, says, you had to keep it in place for 4 years. There's no requirement that I keep it in place for 4 years.
Well, let me ask you, what if they drilled the well and then the next day closed the well and salvaged the equipment? Would that not have been a breach?
If it would not have been a breach if the well was capable of receiving a minimum capacity. He couldn't guarantee the presence of saltwater. What he could guarantee was, I'm going to build you something that works. And if this something works, we already have the supply. We need the receiving vessel. The trial court said that was a guarantee of return. Well, it's not a guarantee of return, because what it doesn't say is, even if this doesn't work, and even if I don't receive saltwater, I'm going to pay you back your $250,000. Now, what the trial court also ignored is that $194,000 went into the ground in Oklahoma. And so, at the end of the day, the trial court takes these two whereas clauses, that they plan to build other wells and that they plan to build a second well, and say those were promises of performance. This is in the preamble of the contract. And then that those promises were breached because he did not return within 4 years the $250,000. Now, what's interesting about this is an interpretation of a contract. Mr. Farrell, the owner and operator of S&E, his testimony is clear. He didn't know what these terms meant. So it's not as though they're matching the intent of the parties at the time. You had an oil field industry professional, and you had an investor. And the investor got themselves into this contract without knowing what the terms meant. Then after the other oil well doesn't work out, and that's important, because this suit was filed prior to the 4 years. This suit was filed 6 months after this contract was signed, not 4 years. So at the time the suit was filed, and here's my issue with the summary judgment. At the time when the suit was filed, and the court says in January of 2007 that we breached it for not keeping it open for 4 years, as if that were a requirement. At the time the suit was filed, there's no way to have breached it, because it was open and operating and ready to receive fluids, and the lease was current. There was no amendment of the complaint. So then we get to this evolution of a new theory of how we breached at summary judgment. And the new theory is, well, you didn't keep it open for 4 years. Well, how do you know that? Well, in the last 3 years, you closed it. Well, that's since you sued me for not completing it in 120 days. What about that element? We go to trial and have all this.
So they filed as soon as they saw the oil well was not producing.
As soon as the oil well clogged up. Because the idea is the oil well has failed, so I'm not making any money off that. It doesn't matter to them that the saltwater well is sitting there empty and unused, but it is ready to go, has the capacity. The oil well fails, and of course the oil well contract is not part of this record. It's one of those investment contracts. There's no opportunity for relief on the oil well contract. So we go to the saltwater disposal well contract and construe it after the fact as a performance, as a promise of guarantee of return.
Well, what about paragraph 16?
Okay.
Which says that in the event that S&E has, for a period of 4 years, has not recovered its capital investment plus 7%, Advent would be obligated to pay S&E an amount equal to what has not been recovered. Why is that not a fair reading of the contract?
Because there's a next sentence that says the amount paid by A&O, which is Advent, would not exceed the amount paid to A&O as its share of the net revenue. They were co-investors. They rose together and they fell together. And After the revenues were coming in, when the money was rolling, it was a 75-25 split. But if after the expenses, S&E was not getting its 75, then Advent would first defer its 25, and that's what it says. And then it would not receive its 25, but it would pay back S&E, but only to the extent that it got paid. It's being paid out of profits. It's interesting, this joint venture versus investment contract, first time we see that is in the final judgment. You can try by consent, but you can't when the first time you see a concept is in the final judgment, paragraph E, which is that this is an investment contract versus a joint venture.
Right, that has something to do with the blue sky laws, right? I mean, what does that got to do with that?
It's a good question. First of all, it has nothing to do with what the words of the contract says, how you characterize it. But it was brought in to rationalize and justify getting him his money back, which is, no, this was an investment contract. It wasn't a joint venture. Truthfully, we didn't brief joint venture versus investment. It was none of the legal briefings. It was never argued. I don't think I ever said those words. It shows up in the final judgment as part of that rationalization. The same way that the trial court went and looked to the two whereas clauses, and where it says I plan to, change that to I promise to, I'm going to. Because what the parties planned to do was what the parties planned to do. It's important to note, there's no fraud claim, there's no misrepresentation claim. There was never a suggestion that any of these things they planned to do were false or inaccurate or were not going to happen. They in fact happened. The well was constructed. The hole in the ground was built. It cost $194,000 to build. And then the trial court said, no, this was an investment contract.
It cost Advent that much, or that was the price for the total?
It was the hard cost. As a matter of record, the hard cost. We produced invoices and receipts showing where $194,000 went into that hole in the ground, which was including the drilling and the mudding and all of the technical aspects that you do.
All right, so what happened to the difference between that and 250?
Well, the record, and the reason I key in on the 194 number is because I can determine that out of the hard cost. I can add it up. There were soft costs that were testified to, but I didn't add all of those. The fact of the matter is it may have come in under 250. That goes to the turnkey nature, and it's interesting because this contract was a turnkey contract. Their expert agreed with our expert. Turnkey is a financial term. You're going to put $250 in and not a dollar more. If it costs more than $250, we have to pick up the charge. And so it was a turnkey contract. It was to be completed and operational within 120 days. One word about that. I'm into my rebuttal. Completion is an industry term set by the industry of the Oklahoma Commission. It is a legal term. They require you to report that. The evidence in the record, I think it's 200, shows the completion report. So there's no question about when it was complete. Thank you. I'm going to reserve my time for rebuttal.
I think there is a question because you didn't get the permits until after the 120 days. That's
right. And if you look at the completion and operational section, it has the 120 days requirement. The testimony by Mr. Lowther at Advent was, I never thought I could get all my permitting in 120 days. The issue was, how quickly can we start putting salt water into this hole in the ground to save us money on the other well? The full permitted, the turnkey aspect does not have a 120-day requirement to it. They're separate paragraphs of the contract. They don't even relate to each other. And the trial court, of course, related them in some way, much as they swooped in the whereas clauses to make this guarantee. I need to save 2 minutes if I can. Thank you.
Good morning. I'm Parker Smith. I practice in Destin, Florida. I represent S&E Enterprises, LLC, the appellee in this case. I tried the case below against Mr. Beasley, who did a superb job for the appellant. I have Mr. Farrell, who's the principal of S&E Enterprises, present in the courtroom, along with paralegal Gail Smith, who did all of the work in assembling the briefs and the exhibits for the trial, who runs our office in Destin, and whom I've practiced with for 20 years and I've been married to for 12. So now she has to deal with what happens the night before oral argument when the counsel can't sleep and is anxious and is concerned about can they answer the questions that come to them. We don't get this opportunity that often. But I'd like to point out to the younger lawyers in the courtroom briefly that this is our highest calling. We don't get to do this very often, and I really appreciate being here. It seems like every year there are more and more younger lawyers in the courtroom besides myself. They're all younger now, and I tell them, if you get a chance to argue in the Court of Appeals, take it, because it's great. Really happy to be here. Judge, judges, justices, this is a contract case. We, as a law professor of mine said 45 years ago, when you have a contract case, you have a piece of paper, and the piece of paper has life to it. The piece of paper contains not only words, but the piece of paper tells you about the intent of the parties that drafted it, that put it together, and that lived by it, and in some cases that fell by the wayside because there was a breach. So in a case like this, the contract is king. We have to look at the agreement. It's interesting the excuses that the appellant has for non-performance in this case. Let's look first at a paragraph that has not been referenced yet, the fact that oil wasn't flowing from other wells. That was accounted for by the parties in this contract in paragraph 21. With permission from the court, I will quote that. O&O, which is Advent, and Lowther, and S&E agree that the joint venture ownership agreement pertains only to the saltwater disposal well at the location described in Exhibit 2 and separate from other investments and agreements S&E may have with O&O. There is no condition attached to this contract that the other oil wells have to produce oil for Mr. Farrell and S&E to recoup their investment. That was specifically not included in this contract. And, of course, the trial judge found that in many other respects the contract had been breached. In what ways, in your estimation, does this agreement differ from a simple promissory note? It's not a loan, first of all. It's a participatory contract to a certain extent. There is some responsibility on the part of S&E to participate in monthly operating expenses of the SDW, up to $1,500 a month.
All right, so what provisions should we look to understand what happens if the enterprise fails?
They're specifically covered in the contract, which is why it's such an interesting document. The contract provides that if it doesn't produce, I believe that's paragraph 4 of the contract, that they will be liable for an amount up to the investment. And get that contract language and read it exactly. Paragraph 6 and 7 have to do with if the SDW is not completed and operational in 120 days in accordance with Covenant 5. And by the way, we produced copious testimony it was not, by many different witnesses, including our expert, who was not operational because it had no permit.
But otherwise it was receiving salt water, right?
For a very brief period of time. This well only generated $2,500 worth of income at the highest level. So the entire investment basically was lost here.
But that's the reason, because there was no salt water to dispose of.
But
not because of any timing about.
Well, timing was a factor. Timing was of the essence in this agreement. It was made to be a factor.
How much more money would have been earned if the permit had been issued or permits had been issued within 120 days? There's
no way to tell in this contract because Advent did not aggressively seek other aspects to produce oil and salt water for this well, which is a specific agreement in paragraph 2 of the contract. AONL will drill, develop, and provide engineering, furnish all permits and from the appropriate authorities, and maintain the SDW, holding them harmless, and agrees to aggressively seek other producers. They didn't do that.
Well, counsel, isn't the fact that they didn't have time to before the complaint was filed in March 2004, just, a couple months after the SDW had been completed, they didn't have time to seek other uses?
Well, they didn't do anything to seek other users, according to our expert. He said he found no evidence in the record that they had done anything to seek other users of this well. They obtained the wrong permit to aggressively seek other units. They got a private permit instead of a non-commercial permit, and they blamed it on the fact that the lease was inappropriate for what they wanted to do on the site. The lease wasn't part of this agreement. Mr. Farrell and S&E had nothing to do with the lease. It was not made a condition of performance under the contract. So they had 4 years to get moving, which they didn't do. So I would say that the filing of the lawsuit was probably immaterial to whether they could produce other wells that would assist this well or not.
And assuming we agree with both parties here that or disagree with both parties here on timing, i.e., we disagree with the appellant that your timing of your suit has any significance, and we disagree with you that the permitting issue and the 120-day problem is dispositive. So putting away those timing issues from both sides, you cited paragraph 4 that required the appellant to aggressively seek other sources of salt water, right? Is that, and of course we've read the contract, but do you think the contract clearly states or imposes an obligation on the appellant to produce salt water so that you will receive the income?
I think they have to make efforts, or it's a breach. I mean, it's a question of breach, but I agree with the court personally as to the 120 days, how much more revenue could have been made in an extra month. I mean, there's no way to tell.
Right. Like I said, assuming hypothetically we just disagree with both parties on their timing arguments, but we look to the contract to say, was there a legal obligation by the appellants to generate revenue? Or was the agreement to build a saltwater disposal well?
And that's what Judge Stone found would have been an absurd result if it was just an agreement to build a well.
And why would that be absurd?
Because the intent of the parties by this agreement is a revenue producer with guarantees of performance. It's not a construction contract. And by the way, the issue of whether they spent $194,000 in building the well is irrelevant, because
I agree.
They don't get to subtract that from the investment.
I agree. I think the issue is, well, I mean, I understand your argument. So the issue is, it seems to me here that, is this an agreement that guarantees you revenue, or is it a joint venture by which your client invests and hopefully we receive $275,000 a year plus 7% annual interest, and maybe we don't?
And our expert testified it was a revenue contract. He testified this is the type of contract that he sees, although he's never seen one just like this because it was a one-off contract. But this is a revenue contract. The CPA testified this contract had strict accounting requirements in it for furnishing information, none of which were followed by the appellant. No tax returns were ever produced. No accounting records were ever furnished. Only slips of paper from the field that total $174,000, not even checks, were produced. The CPA
Mr. Smith, what do you do with paragraph 24? That reads, if it becomes necessary to plug and abandon the saltwater disposal well, the cost, as well as the money from the recovery, would be shared 75% to S&E and 25% to Advent. Why isn't that the limit of their responsibility? As I understand it, basically nothing was recovered.
Nothing. It says if you have to plug the well and abandon it for some reason. It doesn't say that you can salvage the well without notice to the investor a year after litigation.
Is it your position it was that they plugged and abandoned the well when it was unnecessary to do so?
We'll never know. But it was unilateral on their part, without notice to the investor. That's what notice provides. What a number of witnesses testified, even their witness, Mr. Stetnish, who I do not regard as an expert witness, I regard him as a field man, a fact expert, testified that you have to notify the investor before you salvage the well. Give him a chance to do something with it. In the middle of litigation, just consider this. Litigation is filed in March of 2004. In December of 2005, the well is removed, sold for salvage, without notice to the litigant. This is not just to a party. This case is in court at the time. The plaintiff is trying to get financial records and trying to find out what happened, and they sold the well without telling them. What does that tell you about intent here? To perform under the contract. There was no intent to perform.
Well, I believe their position is that the lease required that
the lease has nothing to do with this
well
contract.
be plugged and the land be restored to its prior condition, the land lease.
The land lease has nothing to do with this contract. It's not even referred to in the contract. Mr. Farrell had no knowledge of the land lease until the day before trial was held, to testimony on damages. they could have involved him in the land lease or made it conditional upon extension of the land lease. Everyone has business connections or situations where you're running a business. You're set up, for example, leasing boats, and you have a lease where you keep the boats. You have to have that location to lease your boats, but you made a mistake. You only made the lease for 5 years instead of the 6 years that you have the boats for your business. You take the risk of a lease being canceled or terminated and it affecting your business. So you build it into the contract. If there's some problem with the underlying land lease, this is an exculpatory or, it's a condition or something like that. There's nothing there in the contract to specify that. It sounds to me like a red herring. We will never know. Mr. Young was not a witness in the case. He didn't testify. Only person that says the land lease was a factor is Mr. Lowther, who didn't produce any records, who salvaged the well without notice, who didn't do any production, who basically ignored all of his responsibilities under the contract, not just these. Didn't have it operational in 120 days, didn't have the land lease as a condition, didn't discuss the land lease with the investor, didn't produce any financial records that he needed to guide him as to whether what was going on was appropriate or not. Didn't aggressively seek other uses for the well, got the wrong permit.
Now, you didn't draft this contract.
No, I did not draft this contract.
Now, what if, in reading the contract, we decide that there are some ambiguous or inconsistent provisions, that there's ambiguity in the agreement as a whole?
Yes, sir.
Wouldn't it be appropriate to send it back to give people an opportunity to address with evidence?
Well, we did that. If you look at the trial record in this case, although it was a trial on damages, everything came in. The kitchen sink came in. It was 2 full days or close to 2 full days of trial testimony on the inconsistencies, the ambiguities, what words meant, what parties intended, the purpose of which ostensibly was to show that this was an investment contract with guarantees instead of just a construction contract. But it's all come in. The judge has made his decisions based upon what he heard from the witnesses as to what they intended.
Didn't he make his initial decision on the basis of before he heard the evidence?
Well, he made a decision on liability before he heard the evidence. He made a decision based on the motion for summary judgment. The motion for summary judgment was not, as it was characterized, a motion that we were entitled to judgment because the well hadn't been operational in 120 days. No, it wasn't. The motion for summary judgment was clearly framed on paragraph 7 of the agreement that they were obligated to maintain and keep in existence the well for a period of 4 years to allow a return on investment, and beyond that, on a sharing basis for more than a return on the investment. That was clear because they said they salvaged the well because the land lease expired. The land lease wasn't a condition of the contract, and the lease wasn't ever even referred to in the contract itself. So their reason was a reason, but they agreed the well was not there. It couldn't produce any revenue, and that's why summary judgment was granted. They did not argue, or they didn't put in their motion, or their response to the motion for summary judgment, that they were being blindsided by this concept. They couldn't have been blindsided because they are the ones that salvaged the well in the middle of litigation. They didn't put that in their response. And their response was they blamed it all on the lease. That was their response. And the judge said there's no issue of material fact here because you were obligated to keep it in existence for 4 years so he could have recovered his investment. When you salvaged it unilaterally, you took that away from him.
So your argument is they assumed the risk that the oil well would not produce. They essentially covered and promised that we will produce the salt water. You pay for the salt water, or you pay whatever proportion of the well. We will produce the salt water, and you will
Profit.
receive revenues from it.
Right. And if we can't do it with Payne 1, we'll do it with Payne 2.
And that's the provision regarding that, requiring them to aggressively seek other sources.
Exactly. And because they got the wrong permit, they couldn't go outside the Payne lease to get other users. They had to do it as a private matter on the Payne lease, but they didn't do anything on that lease. They didn't drill any other wells. There's an interesting testimony from James Pyland, who was our expert, who has been in this for over 20 years in Oklahoma, who said this saltwater disposal well could never have produced enough revenue on just the Payne lease. There wasn't enough oil to produce on that lease. Even if they had drilled 12 wells, they couldn't have done it. So they were shot in the foot ab initio because they couldn't go elsewhere. They had the wrong permit. That's why the case should not be remanded to the trial court, because it's already, and if you look at the record, you'll see how broadly the case was tried and the issue of damages for 2 days. I think some of the cases that Robert cited and I cited in our brief, probably for a different reason, is trial by acquiescence or words to that effect, where you've had a summary judgment that you go forward and you bring in more testimony to flush it out. And in this particular case, the ambiguities didn't have anything to do with the breach, the initial liability finding by Judge Stone. There was nothing ambiguous in that clause.
All right, thank you, Mr. Smith. You're a minute over, and we will give an additional minute to Mr. Beasley.
Mr. Beasley, tell us again, Judge Benton asked you, your interpretation of the contract means your clients could build this saltwater well on Monday, capable of handling the saltwater, Tuesday in the middle of the night, shut it down, salvage the well, send the appellees a check for $2,000, and say, sorry, it didn't work out. Under your interpretation of the contract, that's a reasonable interpretation.
Well, taken to the fact scenario to the extreme, yes. Because
all your client had to do was build a well capable of receiving that amount of salt water that would produce that revenue. That's it.
what we ask the trial judge to do is look at the language of this contract and interpret it. And what we're asking this court to do on a de novo basis is look at the final judgment. And where it says Advent promised to develop a number of wells, go to the contract and say, did they promise? And you'll find, no, they didn't.
Did they promise to aggressively seek other sources?
Well, that was kind of mixed around because co-counsel said it was in paragraph 4. I think he meant paragraph 7. But it's not in 7 either. It's back in a whereas clause. You got to go back to the third whereas clause, and it says, agrees to aggressively seek additional usage of the saltwater well through their own well development. Again, the question is, what did they promise to do and what did they contract to do? They promised and contracted to build a well that was sufficient capacity. That's what they built. They didn't promise to truck salt water from anywhere. And they didn't promise to build other wells. They didn't contractually bind themselves. In fact, it was pointed out that the parties put in here, this has nothing to do with our other well agreement obligations. Because what they're building is a facility to receive. But
it's also irrelevant, isn't it, as your opposing counsel states? Your client's problems with the lease are your client's problems, right? Not his client's problems.
That is correct. And there is no record testimony. You can't find any record testimony about aggressively seeking wells or building other wells. There is 1 or 2 questions to my client where he says, isn't it true you didn't aggressively seek the well? And he said, that's not true. The first well failed, and then I got sued 6 months after this agreement when the saltwater well was in place, and then my landlord wouldn't renew. And so the only record you have that he didn't aggressively do it is argument by counsel on the other side and the answer of my client. They put on no evidence at all about this failure to aggressively seek. It's just a presumption that he didn't do so.
Well, it didn't happen. And so it's irrelevant perhaps how it's argued because it had to be shut down.
It had to be shut down.
Stripped to its essentials, your argument is here, read as a whole, this contract imposed no obligation on your client to bring in salt water, only to be capable of handling the salt water.
And it is true that the parties intended a different result. There is no doubt. They went into a joint venture intending a different result. The word joint venture is mentioned 7 times in this agreement in different paragraphs to include the money put in is classified as venture capital. Secondly, they also agreed that they would be treated taxed as a joint venture. This was a joint venture. They went in together, they failed together, and now one side wants their money back.
And you don't want a remand. You want a reversal and summary judgment granted for your client, I take it.
No, what I've asked is that, and upon de novo review of this contract, the court determine whether this judgment is a fair and adequate plain reading of this contract.
I mean, under your argument, we should order the summary judgment be entered in favor of your client, right?
Truthfully, we want to try the accusations that are now resulting in the final judgment. We tried whether we built it in
But
120
I mean,
days.
may I, Judge? I'm sorry.
Surely.
If your client's argument is, if your argument is correct, then your client has met his obligation, and he doesn't owe the appellant a penny.
It
I
would
mean,
be,
the appellee, right?
that is correct, but it would be nice to have the opportunity, other than in the final judgment, to address these allegations that we breached provisions of the contract that
I
we
mean, is
didn't
that
think were
legally
obligations.
relevant? Are you objecting if we want to write an opinion and say we're going to reverse with directions that summary judgment be ordered?
I would never object to that, Your Honor. Thank you for your time.
Thank you, Mr. Beasley.